Assalamualaikum. My name is Wan Ammar Thaqif Bewa Muhammad ROZANI and my group members Muhammad LUQMAN bin AZMI, Muhammad LUQMAN SYAHMI bin ABDUL KAHAR and Muhammad FAKHRI bin Muhammad Nur. We are presenting a topic from IMU 502 syllabus, which is the application of buying Al-Istisna contract in operation of Sukuk Istisna. There are many sales contracts contained in Islam, and each is implemented in various forms and applications. One of them is buying al-istisna. Buying al-istisna is one of the methods of financing in Islamic muamalat. The sales and purchase contract based on al-istisna was practiced by the Muslim community during the time of Rasulullah SAW in the sale and purchase between the seller and the buyer. Buying al-istisna is a financing methodology based on Sharia law and pure Islamic values applied in the al-istisna transaction. The implementation of buying al-istisna provides convenience to both sellers and customers in every step of the transactions, but there are still many who do not care and use this buying al-istisna contract. This may be because the level of understanding of al-istisna is still lacking or confused about this concept. The meaning of buying al-istisna, which can be easily understood by today's society, is to order something to the maker. Examples are ordering clothes, pens, and furniture. In addition, another example is the booking for the construction of houses, rooms, and so on. The meaning of al-istisna, which can be agreed upon by the scholars, is to order, ask someone to do something, and do something based on someone's request. While the meaning in terms of terminology, there are various disagreements by the scholars in the legislation. According to fuqaha, their first view of buying al-istisna in terms of terminology means asking the maker to do something specific in a specific way. The second view is that al-istisna is a contract to ask to do something or to book on the work of a person who has determined these dependent and incomes. And the third view, al-istisna is the contract of buying something that he ordered to the order maker. The fuqaha of the Hanafi school state the meaning of al-istisna as a contract on goods ordered on a loan provided it is made according to what is requested. According to the Hanafi and the Hanbali schools, they categorize buying al-istisna as buying and selling something with conditions. Buying al-istisna is not the same as buying al-salam. They also argue that the implementation of buying al-istisna is a must or harus because it does not conflict with the principle of sale and purchase. The Messenger of Allah, Muhammad SAW, has said in the hadith, "La tajtami'u ummati ala dhalalah." My people do not gather or alight on something that is wrong. While the Maliki and the Shafi'i school equate the method between buying al-istisna and buying al-salam, it is because both involve the ordering of goods. But what makes it different is based on the types of items ordered. In buying al-salam transactions, the type of goods ordered is in general form. For example, such as online purchases. The shape, specifications, quality, and quantity of goods have been described in detail. On the other hand, the types of goods ordered according to buying al-istisna transaction are more specific, and there are not many available in the market to look for. It needs to be made or built at the beginning of the transaction to purchase and get what is ordered. Shafi'i school thinks otherwise compared to Hanafi schools. The opinion of the fuqaha of the Shafi'i school is that the law of the application of akad al-istisna is not necessary because it is based on the concept of qiyas. For anyone who makes an order of goods should follow every step done in Bay al-Salam. This is because the application of the concept of Bay al-Istisna is seen as a sale that is not in the hands.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Muhammad FAKHRI bin Muhammad Nur. So here I want to present about time of delivery in by Al-Istisna. Okay, in Istisna contract, the Islamic scholars do not require a specific time. Okay, it's because if we look at the available reference that talk about the time or delivery in Istisna, the Islamic scholar do not require a specific time. Okay, next, so the purchaser or manufacturer will set the delivery time according to mutual agreement. As point out early, and it is not necessary in Istisna that the time of delivery is fixed. However, the purchaser may fix a maximum time for delivery, which means that if the manufacturer delays the delivery after the appointed time, he will not be bound to accept the goods and to pay the price. Okay, next, the delivery risk. So in delivery, the risk in delivery is delay in delivery of good from the producer to the customer at maturity. So the solution is link pricing of the istisna to delivery in order to ensure that the goods will be delivered within the specific period. Some modern agreement of this nature contain a penal clause to the effect that in case the manufacturer delays the delivery at the appointed time, he shall be liable to penalty which shall be calculated on daily basis. So the penalty here is the price of the asset. Next we go to the next slide. Termination of the istisna contract. As one of the nominate contract in Islamic commercial law, istisna is terminated by the normal ways of termination of contract, namely when manufacturer make the commodity and present it to the purchaser and retrieve the payment. Furthermore, this istisna contract also can be terminated by the death of one of the contracting parties. But it must be different between a contract of istisna between individual and one which involve corporation and companies. In the former case, it will be terminated by the death of one of the contracting parties, but in the second case, It will be continued as long as the corporation or company is in existence and will not be affected by the death of its member. It is not validity, amendment, and cancellation. In order for the it is not to be valid, the price must be fixed from the outset. In the event of any unforeseen event that cause a delay in delivery, the price of istisna can be amended if it is mutually agreed. After the manufacturer has started the work, the contract cannot be cancelled unilaterally. Operation of Sukuk Istisna. Sukuk Istisna is a financial certificate issued based on the principle of istisna. The sukuk issuer will act as the asset booking supplier, while the sukuk holder will be booking buyer. This sukuk refer to the ordering of asset involving the manufacturer of carpentry, such as residential building, road, and machinery. The sukuk issuer will act as an asset buyer rather than the sukuk holder. The transaction process is done in the following ways. First, sukuk producer issue sukuk to raise fund. Second, sukuk holder purchase sukuk from the sukuk issuer as payment for the asset book. Third, after the asset ordered are ready, then the sukuk issuer submit the asset to the sukuk holder. Sukuk holder earn in two ways. First, the purchase price of an asset lower than the value of the sukuk. The second way is namely sukuk is traded in the secondary market. Besides financial project, mainly in infrastructure, istisna sukuk are usually issued for funding large construction and manufacturing project, such as airport, commercial building, bridge, power plant, and others. Since the issuance of istisna sukuk is based on sale contract where the price is paid on a future date. The sukuk are issued to represent investors' right to the debt owed by sukuk issuer. Istisna sukuk to represent istisna selling price. Okay, we look at the image or figure. First, under istisna purchase agreement, the originator or issuer agrees to construct and identify istisna asset and deliver it to the investor in consideration of an agreed istisna purchase price. Second, the istisna purchase will be paid by the investor in one lump sum or by stage at a specific time. The proceeds will be used to finance the project. Third, subsequently, the investor enter into the second istisna transaction or istisna sale agreement and agree to construct the identified istisna asset of and agree to construct the identified istisna asset for the originator. The selling price, which is made up of the original asset purchase price, and the profit margin is payable according to an agreed payment schedule. Next, the originator or issuer will issue sukuk to the investors and evidence for usual financial obligation on the settlement of the price. Lastly, the payment will be settled in periodical basis. For example, semi-annual. The sukuk shall be redeemable upon maturity. Istisna sukuk to represent istisna asset. So we look at the figure 2 or this image. First, the issuance proceed received by special vehicle purpose or SPV as trustee of sukuk investor are used to finance construction project. Second, sukuk are issued to investor by SPV. Third, SPV execute an istisna contract with a contractor to boot an identified asset which is to be delivered on a specific future date. Fourth, the istisna per cash price is settled on stage basis and at specific time. Fifth, during the construction, the SPV lists the istisna asset under the principle of ijarah mausufah during this construction, the SPV lists the istisna asset under the principle of ijarah mausufah fi dhimah or forward lease. Next, the end user will pay the rental to SPV at an agreed formula. Proceed received for the end user in distribute to investor periodically. Example, semi-annual basis until maturity. Lastly, upon completion of the project, the asset is sold and delivered to the end user.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Muhammad LUQMAN SYAHMI bin ABDUL KAHAR. ID numbers 2019252818. Okay then. Now, I would like to share and present to you about the topic, the condition of istisna contract. Okay then. First thing first, we go through to the outline of the presentation. The first is we want to know the condition for the legality of istisna. Okay, for this condition is divide two type of the condition. The first is general condition and the second one is the specified condition. Okay, for the type of condition for the legality of istisna, we discuss about the general condition. Okay, in the case of general condition, the istisna sale must fulfill the requirement of a valid contract. It means we should to fulfill the requirement to make a valid istisna contract, which is we should to have a sum of characteristic in the condition, such as the capacity of the contracting parties. Next, the subject matters, or we understand that the object or the thing that we use in the contract. Then the last one is offer and acceptance between buyer and seller. Okay, now we discuss about the specific condition. There are some of characteristic in the specific condition, such as the object must be precisely and clearly determined in terms of its type, kind, quantity and quality. It's because istisna is a sale of non-existent and exempted from the original rule of sale. Second is the recommended manufacture item should be things that people customary deal within the field of manufacture. Otherwise, the contract of istisna will be invalid. Okay. The next condition is about the time of delivery. This means the seller or buyer should to inform first or discuss each other about the specified whether it is short or long so as to avoid ignorance, which might lead to conflict between the two parties. Okay, next, the material should be supplied by makers. If they are supplied by the buyers, the contract is regarded as al-ijara and non-istisna contract. The last condition is about the place of delivery. The place of delivery is stated if the commodity needs loading or transportation expenses. Okay, it means the seller should tell and inform first to the buyer about where the post-delivery item are stayed. If the commodity needs loading or transportation expenses or the service. Okay, now we discuss about the subject matters of istisna. Subject matter is the object or the thing that we use in the contract, which is we should to have a sum of condition for the object, such as first, in the contract, the item valid only for those objects that have to be manufactured or constructed. The subject of istisna must be known and specified to the extent of removing any ignorance or lack of knowledge of its kind, type, quality and quantity item. In istisna contract, the manufacturer arrange both the raw material and the labor. An istisna contract also may be drawn for real estate development. In the subject matters, there are some type of invalid item. Invalid item for natural thing or product like animal, corn, fruit and else. After that, it is not permissible that the subject matters of an istisna contract be an existing asset. Okay, that's all from me. Sorry if any mistake in my presentation. If any problem, all of you can personally face to me or my group. Assalamualaikum warahmatullahi taala wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad LUQMAN bin AZMI, and today I will present and share to you guys about the difference between Sukuk contract in Malaysia. The Accounting and Auditing Organization for Islamic Financial Institution AAOIFI, which issues standards on accounting, auditing, governance, ethics, and Sharia standards, has set 14 different types of sukuk. There is 14 types of sukuk. A total of 7 sukuk are mostly used in Malaysian sukuk market, including sukuk istisna. The structure of the sukuk depends on the creation of the specific purpose vehicle, SPV. So SPV will issue a sukuk which represents the undivided ownership interest in the underlying asset, transaction or project. A special purpose vehicle or SPV is a company registered as a subsidiary with legal status that allows it to secure its asset structure in such a way that the respective entities will not be affected in situation where the parent company goes bankrupt. In other words, the SPV is a bridge that helps the parties involved in the contract to get their shares accordingly and to monitor their rights. Okay, let's go to first sukuk, which is sukuk mudharabah, profit and sharing. It is certificate that represent projects or activities that are managed on the basis of a mudharabah partnership based on trust contract. There will be one party or partner called the mudarib who will manage the project. Beside the mudarib, there is another partner called Rabbul Mal, owner of capital, who is the capital provider of the project and own shares in the mudharabah equity, where his or her returns will follow the percentage of ownership share. In a mudharabah sukuk, the sukuk holders are the silent partners who don't participate in the management of the underlying asset, business, or project. The working partner is the sukuk obligator or issuer. So this is the image. Investor Rabbul Mal and originator Mudarib, managing partner. So they invest fund and return of profit in Mudarabah capital. So let's go to the second sukuk, which is sukuk musyarakah, profit and loss sharing. The term musyarakah is derived from the word syirkah, which means partnership. A musyarakah arrangement is a partnership arrangement between two or more parties where each partner makes a capital contribution to the partnership in the form of either cash contributions or contributions in kind. The musyarakah partners share the profits of the musyarakah in pre-agreed proportions and share the loss of the musyarakah in proportion to their initial capital investment. So they will share the loss between them. So this is the image. They share profit and loss. So the investor is sukuk holders and obligators managing partners. Okay, let's go to the third sukuk, which is sukuk murabahah, cost plus sale deferred payment. Murabahah is broadly understood to refer to contractual arrangement between an investor, which is the seller, and an originator, the purchaser, whereby the investor will sell specified assets or commodities to the originator for spot delivery in the expectation that the customer will be able to meet its deferred payment obligations under the Murabahah agreement. So there deferred payment. The deferred price will typically include the cost plus profit margin basis at which the investor had purchased the assets or commodities, plus a pre-agreed markup representing the profit generated from its involvement in the transaction. So there's the image. Investor, the seller, will make a profit from originator, the purchaser. And the fourth, sukuk al-wakalah. It means agent. Al-wakalah structure stems from the concept of wakalah, which means an arrangement whereby one party entrusts another party to act on its behalf. In general, it is a contract in which a party authorizes another party, usually an agent or wakil, to act on behalf of the former based on the agreed terms and conditions as long as he or she is alive. Here, a wakil could be appointed to manage the wakalah portfolio with the aim to generate an agreed upon profit return. So, there is wakalah agreement, investor and wakil, they will get trust each other. The fifth, sukuk ijarah, that is leasing. Ijarah is broadly understood to mean the transfer of the usufruct of an asset to another person in exchange for a rent claim from him, or more literally, a lease, the legal right to use someone else's property temporarily and to keep any profit made from it. Basic idea of ijarah is that the investor, which is sukuk holders, are the capital providers of the asset and are entitled to receive a return when that asset is leased. In this scenario, the SPV, which means the lessor, receive the sukuk proceeds from the investor. In return, each investor gets a portion of ownership in the asset to be leased. So that is the image. Originator, SPV, first sell asset, second sell sukuk, third they give money, cash, and lease back, pay rental revenue, 7 and 8, buy back asset at maturity. So that is the last one. Sukuk salam, deferred delivery purchase. Salam contract involve the purchase of assets by one party from another party on immediate payment and deferred delivery terms. The purchase price of the assets is typically referred to as the salam capital and is paid at the time of entering into the salam contract. So, paid at the time. This contract may be construed as being synonymous with the objective of a forward sale contract. Forward sale contracts are generally forbidden under Sharia unless the element of uncertainty, that is gharar, inherent in such contract is effectively eradicated. For this reason, certain criteria must be met in order for a salam contract to be Sharia compliant. So that is the image. The investor invests in a future sukuk project and ordering sukuk SPV, ordering sukuk asset and manufacturer delivering sukuk asset, and SPV will sell asset to customer. Customer will accept payment, and profit and cost of project get back to investor.
Based on the study we have obtained, it can be concluded that buying al-istisna defined as a contract in which the seller sells an asset to the buyer to be made or built based on the agreed specifications, then can be completed on the agreed date at a set negotiation price at the beginning of the transaction. This financing concept complies with Sharia law because it does not involve elements that should not be. Based on the Financial Stability and Payment System Report 2016 by Bank Rakyat Malaysia, changes in the application of Sharia contracts for Al-Istisna contract financing shows only 17% of its use based on the value of financing from 2014 to 2016. The percentage issued is very small compared to industry expansion or areas another. Therefore, the public needs to be more aware of the application of buying al-istisna in dealing, especially traders and corporate entrepreneurs in the booking of or manufacturing industry, so that the economy grows with the current development of Islam. Thank you for us. Assalamualaikum warahmatullahi wabarakatuh.